How do property rights apply to software and digital information? Have you ever wondered how property rights work when it comes to software and digital information? This is a fascinating topic that touches on the very essence of ownership in our digital age. Traditionally, property rights involve control over physical assets, like land or personal belongings. However, software and digital information are different because they are intangible and can be easily copied. This creates challenges when applying the traditional concepts of property rights. From a libertarian viewpoint, property rights are based on the idea of individual ownership. This ownership is often acquired through original appropriation or homesteading of resources that were previously unowned. When it comes to software and digital content, the situation becomes tricky. The creator of software does not physically consume or remove the resource when someone else copies it. This leads many libertarians to argue that extending traditional property rights to software and digital information can create state-enforced monopolies. For instance, intellectual property laws such as copyrights and patents allow creators to restrict how others can use their work. A copyright holder can prevent others from using their own computers or paper in certain ways. This goes against the libertarian principle that one cannot control someone else's property simply by creating something new. In the digital age, enforcing intellectual property rights often involves government intervention. This can restrict copying, sharing, or modifying software and digital content. Many libertarians view this as unjust because it grants exclusive control over ideas and information that should be free to share. The rise of the internet and digital file sharing has intensified these discussions. Libertarians often oppose strict intellectual property laws that punish ordinary users for simply copying digital files. Interestingly, some libertarians have historically accepted intellectual property as a necessary form of property. They argue it incentivizes innovation. However, a growing number of libertarians reject this idea, claiming that intellectual property is not true property. They see it as a privilege created by the state that infringes on the rights and freedoms of others. Practical applications of this libertarian perspective can be seen in the support for free and open-source software. This type of software is licensed to allow anyone to use, modify, and share it freely. This approach aligns with libertarian values by promoting cooperation and sharing without government-enforced monopolies. The free software movement arose as a response to the restrictions of proprietary software, advocating for digital freedom and user control. In summary, while property rights clearly apply to physical resources, applying these rights to software and digital information presents challenges. Intellectual property laws that restrict the use of digital content are often viewed as state-imposed monopolies. Libertarians generally prefer market-based solutions, such as free software licensing, over government-enforced intellectual property regimes. This reflects the evolving definitions of property rights in our digital world and the ongoing debate about the government's role in regulating information and innovation.